this video, we are going to present about the overview of the law in the regulatory bodies in Malaysia. The main sources of Malaysian law are as follows. The federal constitution establishes a constitutional monarchy and a federal system of government. The parliament functions and is governed by federal constitution. The parliament amends the constitution by a two-thirds majority vote of both chambers of parliament. The constitutions of the 13 states comprising the federation, which have individual constitutions that provide for a single-chamber legislative assembly in each state. Federal laws made by Parliament. State laws made by state assemblies. Federal and state subsidiary legislation, subordinate legislation or delegated legislation, which is made up of rules and regulations enacted by an authority under powers conferred on it by a statute. Principles of English law suitable to local circumstances. A consequence of British colonial rule was the spread of English law into those areas ruled by the British. Malaysia adopted English law so far as it was suitable to local conditions. Besides, there was statutory authority for the introduction of English law that was suitable to local conditions in the absence of local laws, for example royal charters of justice. In the application of English legal principles to commercial transactions where there is no law, English law as it stood on April 7, 1956 is received in the 9 former Malay states. On the other hand, in Penang, Malacca, Sabah, and Sarawak, English commercial law at the corresponding period is received. This means that in these 4 states, ex-reformer colonies, there is a continuing reception of English commercial law in the absence of local legislation. The dates of reception that are specified are very important because later changes in English law are not automatically received. After that specified date it was up to the colonies of the Malay state to develop or change the inherited law as they saw fit. There is now an increasing number of local laws dealing with commercial transactions with a corresponding decrease in dependence on English law. Islamic law, which is only applicable to Muslims and is administered in the Sharia courts. The power to administer Islamic law is primarily that of the states, except for the federal territories of Kuala Lumpur, Labuan, and Putrajaya. Lastly, the common law is also one of the sources of Malaysian law. 1.2 is about the legislative process. Legislation refers to laws made by a person or body, which has the power to make laws in Malaysia. Both Parliament and the legislative assemblies of each state possess authority to enact laws in their respective areas. Laws made by the Parliament may apply throughout the country or even extraterritorially, but laws enacted by the state can only apply to that state. A federal law is referred to as an act. A state law is called an enactment except in Sarawak where it is called an ordinance. It as opposed to statute law enacted by a legislature, is judge-made law or precedent. A binding precedent is a judgment of a decision of a court of law cited as an authority for deciding a similar set of facts. A court is bound by decisions of a superior court where the superior court had decided a case in the same area of law and on similar facts. While the technique may be English in origin, the resulting common law is naturally Malaysian, although principles of English law may have found their way into the precedent established by the courts. 1.4 is the securities industry law. The legislation which affects the securities industry are Securities Commission Act 1993, SCA. Capital Markets and Services Act 2007, CMSA. Securities Industry, Central Depositories, Act 1991, SICTA, and Companies Act 1965, CA. The SCA, CMSA and SICTA are collectively referred as the securities laws under Section 2 of the SCA. Apart from the 4 acts, subsidiary legislation such as regulations, orders and guidelines issued by the SC supplement the regulatory requirements of the securities industry. So here's the question. Why does the securities industry have specific laws? The answer of the question is, the specific laws are required to regulate the securities industry, primarily due to the distinct nature of securities themselves which are different from other types of properties or assets. One of the primary objectives of securities regulation is to ensure the accurate and timely flow of information to the investing public. The Malaysian capital market regulatory framework has adopted and is constantly benchmarked against the universal standards set out by the International Organization of Securities Commissions, IOSCO. Next, the three key objectives of securities regulations are: the protection of investors, ensuring that markets are fair, efficient and transparent, the reduction of systemic risk. There are three functions of regulation, which are: to define the key features of the capital market system and the role of the securities market institutions, including the development of new types of market securities. To steer market participants towards the adoption of best practices. To create disincentives against behavior that would be detrimental to the market. Let's look at the approach to regulation of stock markets in Malaysia. The regulation of the financial markets has been undertaken in a more streamlined fashion in recent times following the establishment of the SC in 1993 under the SCA. The SC is the principal regulator of the capital market, with Bank Negara Malaysia and the Companies Commission Malaysia, CCM, playing supplementary roles specific to areas within their respective regulatory jurisdictions. Malaysia regulation was shifted to disclosure-based regulation from merit-based regulation. It is access to the public securities markets for issuers is conditional upon providing full and accurate disclosure of relevant information in accordance with parameters established by the securities law and regulations. Properly informed investors can make their own determinations regarding whether the potential return of an investment is worth the risk. Under a disclosure-based regime, the role of the regulator is to ensure the incentives and structure of the market is consistent with efficiency, fairness and safety. Merit-based regulation requires any issues or offer of new securities to be subjected to a review of their investment merit by regulators who may prohibit an offering of such securities if they were judged not to be fair, just and equitable. It is a paternalistic attempt to improve fairness between sellers and buyers of securities in the capital market, as well as to shield public investors from the risks involved in acting on impulse. Next we are going to discuss on the regulatory bodies in Malaysia. Firstly, Securities Commissions was established and began its operation on 1 March 1993 with the enforcement of the Securities Commission Act 1993. The mission statement is to promote and maintain fair, efficient, secure and transparent securities and future markets, and to facilitate the orderly and development of an innovative and competitive market. Securities Commission comprises of 9 members who must be appointed by Minister of Finance, which is a chairman, a deputy chief executive, 4 members representing the governments and 3 other persons. The functions of Securities Commission as listed under Section 15 of the Securities Commissions Act 1993 are as below. To advise the Minister on all matters relating to securities and future industries. To regulate all matters relating to securities and future contracts, takeovers and mergers of companies, and unit trust schemes. To be responsible for supervising and monitoring the activities of any exchange holding company, exchange, clearing house, and central depository. To promote and maintain the integrity of all licensed persons in the securities and future industries. Capital Markets and Services Act 2007, CMSA, came into effect on 28 September 2007 and repealed the SIA and FIA. It consolidated the provisions of the SIA, FIA and the fundraising provisions contained in Part 4 of the SCA. It sets out the provisions relating to the regulation of markets, licensing and conduct of intermediaries, the regulations of market misconduct, fundraising and takeovers. CMSA is benefiting capital market intermediaries by introduced single licensing regime to carry on business in any one or more regulated activity. Next up is Bursa Malaysia Berhad. It is an exchange holding company approved under Section 15 of the CMSA. It operates a fully integrated exchange, offering the complete range of exchange-related services including trading, clearing, settlement and depository services. The wholly owned subsidiaries of Bursa Malaysia Berhad are Bursa Malaysia Securities Berhad, Bursa Malaysia Securities Clearing Berhad, Bursa Malaysia Derivatives Berhad, Bursa Malaysia Depository Sendirian Berhad, Labuan International Financial Exchange, and Bursa Malaysia Derivatives Clearing Sendirian Berhad. Bursa Malaysia Berhad is the frontline regulator of the Malaysian capital market. It has the duty to maintain a fair and orderly market in the securities and derivatives that are traded through its facilities. It has a set of rules to stipulate the requirements that need to be met by the regulated entities either upon admission and or on a continuing basis. Bursa Malaysia Berhad's overriding objectives, in addition to discharging its statutory duties, are investor protection, transparency, high standards of conduct and governance, market integrity and confidence for all relevant persons to participate in the Malaysian capital market. Next 2.3 Bursa Malaysia Securities Berhad, BMSB. BMSB is a wholly owned subsidiary of Bursa Malaysia Berhad, the exchange holding company. It provides, operates and maintains the Malaysian Securities Exchange. It is responsible for the surveillance of its participating organizations, the marketplace, as well as enforcement of its listing requirements which spell out the criteria for listing, disclosure requirements and standards to be maintained by public listed company. The Rules 201 of Bursa Malaysia Securities Berhad is a comprehensive set of rules that prescribe conduct and procedures through which BMSB monitors the affairs of its participants. Objectives of Bursa Malaysia Securities Berhad are: first, to ensure secure, fair and orderly, Section 11 of the CMSA, trading environment through effective monitoring and supervision. Second, to ensure adequate protection of investors who engage the services of the brokers for trading. Third, to effectively monitor the activities of brokers to ensure that they are providing secure and trusted services to investors. Participantship in Bursa Malaysia Securities Berhad. Rule 301.2(1) of the Rules of Bursa Malaysia Securities Berhad states that no person shall have access to the markets or facilities organized and maintained by the exchange, and or be entitled to describe himself as a participating organization of the exchange, unless it has been registered as a participating organization in accordance with the rules of Bursa Malaysia Securities Berhad. Next, the rules that govern the conduct of the participating organizations are: first, prohibited conduct, advertising and staff pinching among participating organizations; second, business interests; third, clients relation; fourth, best business practices; fifth, participating organizations trust account. Furthermore, capital adequacy and other requirements. Capital adequacy requirements are designed to ensure the participating organization are entities of substance so as to foster confidence in the stock market. Participating organization is able to wind down its stockbroking business without its clients or the clients of other participating organizations incurring losses and without disrupting the orderly functioning of the stock market. Investment banks are governed by the capital adequacy requirements prescribed in the Investment Bank Capital Adequacy Framework. The capital adequacy requirement in Rule 1105 address both liquidity and solvency issues together with risks faced by participating organizations. Liquidity risk is liquid capital in the nearest form, where solvency is liquid margin after accounting for a series of identified risks inherent in the operating environment and the composition of liquid capital. A participating organizations other than an investment bank for capital adequacy requirements must have paid up capital and minimum shareholders fund unimpaired by losses of at least Rm 20 million each or such amount as the minister may from time to time determine, and next, set aside each year a certain minimum percentage of its audited after-tax profit in reserve fund. The guideline on investment banks set out that it must comply with the minimum capital funds unimpaired by losses requirement of Rm 2 billion on a banking group base if they are part of banking groups, while investment banks that are not part of banking groups will be required to comply with a minimum capital funds requirement of Rm 500 billion. Rule 1102.1 stated that all participating organization must maintain a continual basis accounting and other books and records in the form and manner prescribed in the rule and prepare and submit the financial report to BMSB. In addition, disciplinary action, First Rule 1302.1 sets out the acts or omissions of a participating which may render the participant liable to have disciplinary action taken against the participant by BMSB. Second Rule 1301.2 sets out the disciplinary powers of the BMSB to reprimand, fine, suspend from trading, Strike off or restrict the activities of any participants found to be in violation of their rules. Third Rule 1301.3 sets out the procedures for the appointment of a disciplinary committee and the duties and responsibilities of the disciplinary committee in relation to the disciplinary proceedings instituted against any participants. Next, accounts, reports and supply of information by participants. First, BMSB must keep proper books for account, which has laid before the annual general meeting, for the exchange. Second, BMSB keeps registers of participants of BMSB, all dealers' representatives, heads of operations, compliance officiers, supervisors, and record all minutes of all general and committee meeting. Third Rule 201.1, J. Require a participant or employee of a participant to give information or provide with documents or information for its inspection, which relates to a matter under investigation by BMSB. Amendments to Rules of Bursa Malaysia Securities Berhad. First, the rules of BMSB can be amended or repealed by SC. In BSP, second, the requirement of the CMSA must be complied with. Any change to the rules may affect any right of third participants must be approved by an ordinary resolution of the participants and the SC. Otherwise, the SC must approve the change. Lastly, complaints and disputes. These issues are covered in Rule 403. First, complaint by a non-participating against participating organization. Bursa Malaysia Securities Berhad will look into the circumstance of the complaint to assess whether an investigation into the complaint is necessary. Second, complaint by a participating organization against a non-participating. If a non-participant fails to meet financial obligation of more than RM2,000, the participating organization can report the non-participating to Bursa Malaysia Securities Berhad provided all the requirement of Schedule 5 to the rules. It can make inquiries, and if it finds that non-participant is a defaulter, it will notify all participating organization that it has done so. A participating organization shall not transact business with such a person. Third, dispute arises between participating organization. In relation to share transactions, either party can bring the dispute to the notice of Bursa Malaysia Securities Berhad in writing. It can decide to act to try to resolve the dispute. If it is unable to do so, it can appoint arbitrators. If Bursa Malaysia Securities decides not to act, the parties to the dispute can resort to any outside tribunal or court. Besides, we are going to discuss on Bursa Malaysia Depository Sendirian Berhad, a wholly owned subsidiary of Bursa Malaysia Berhad. Act 2 operates and maintains the Central Depository, which is Bursa Malaysia Berhad's scriptless electronic settlement process. The Securities Industry, Central Depositories, Act 1991, SICTA, regulates the Central Depository. Section 4(1) prescribes that a company which proposes to establish and maintain a central depository must apply to the Minister of Finance in writing under SICTA. The rules of Central Depository must accompany the application for establishment, Section 4(2)(e), SICTA. Next is Authorized Depository Agents, ADA. Under Section 13, SICTA sets out that a person can be appointed as an ADA to facilitate the deposit of securities. Open, maintain and close securities accounts. Make entries in securities accounts. Collect fees and charges provided for under the rules. And take other incidental and ancillary actions specified in the rules. The person or company must fall within the categories listed in Section 3(2) of the SICTA and appointed in writing to become an ADA. Next is about rules relating to authorized agents. Part 2 of the rules of BMDSB is related to ADA. The duties and restrictions imposed upon ADAs by SICTA are take reasonable security measures to protect information and documents related to the affairs of depositors against unauthorized access, alteration, disclosure or dissemination. Section 42, maintain secrecy of information and documents related to affairs of the depositors and their access unless permitted to disclose information or documents as provided as. 45 of the SICTA, Section 43 and 44. Prohibit of committing an offense in relation to the falsification of records or accounts kept or maintained by the Central Depository, Section 47, and prohibit of committing an offense in relation to furnishing false or misleading information, Section 49. Next is the rules relating to authorized direct members. Part 3 of the rules of BMDSB is eligible for appointment as an authorized direct member, ADM. An eligible person must make an application to BMDSB in writing to determine the application and suitability of the applicant. It can request further information or documents. There is no obligation for BMDSB to appoint every person eligible to be an ADM, however, if appointed, an ADM must pay a fee and thereafter an annual subscription fee. Furthermore, we are going to discuss about the Bursa Malaysia Securities Clearing Sendirian Berhad. It was set up in 1984 as a centralized clearing house to do away with clearing and settlement of scrips on an interbroker basis. The objective are to provide clearing participants with facilities for clearing contracts between them and for delivering stocks and securities, and receiving stocks and securities from each other, and for received or pay any amounts payable to, or payable by, such clearing participants. To provide and to maintain facilities for the custody of scrips on behalf of clearing participants in particular, and other organizations or individuals. And to make, amend and repeal bylaws for the management and control of its affairs and the regulation of its business. Rules of Bursa Malaysia Securities Clearing SDN-BHD. The clearing house rules are binding on clearing participants and can be amended with approval of the SC as provided under CMSA. 2.6 Bank Negara Malaysia. It is a central bank which was set up in 1959. It acts as the licensing and regulatory body over banks and other financial institutions, and provides the stimulus for the expansion and growth of the country's financial sector. Under the Banking and Financial Institutions Act 1989, BAFIA, a financial institution which wishes to carry on the business of banking, being a finance company, merchant banking, or discount house business, must hold a valid license granted by Bank Negara Malaysia. Next, Companies Commission of Malaysia, CCM. It is a statutory body that regulates matters relating to corporations, companies and business in relation to laws administrated, which includes the Companies Act 1965, Act 125, CA. The function is to enhance and promote the supply of corporate information under any of the laws administrated, and to create and develop a facility whereby any corporate information received by it may be analyzed and supplied to the public. Function of CCM under CM: the power to call for information, conduct inspections, investigations, and call for persons to be examined for the purpose of an investigation. Section 711, 7b, 7c and 7d. CA. The power to enforce the filing or lodging with CCM of any returns, accounts or other documents. Section 12(1), CA. The power to take proceedings for any offense against the CA. The power to register prospectuses inviting applications or offers from the public to subscribe for or purchase shares in or debentures of a corporation or a proposed corporation. Section 42, CA. The power to register a company's incorporation by registering the memorandum and articles, and issuing certificates of incorporation, Section 14 and 16, CA.